License. Laurie Anderson versus Emirati Line. Hold on, Ian.
Good morning. My name is Edward Mall, MAHL P27115, appearing on behalf of plaintiff in case that ends in 3911.
Your name? Thank you. All right. So where are we on this case? 8.
This is second hearing on the case that ends 3911.
I'm taking it down here.
Right. But we've got a problem because there's this other case. Do you know about that one, counsel?
Yes, I've heard about that case. Our it had been dismissed and Ms. Anderson does not wish to proceed on that case at this point.
That who?
Ms. Anderson does not wish to proceed on that case at this point.
Okay, but the defendant in that case didn't consent to the dismissal and the court did not dismiss it.
But we're moving that it, go ahead.
Question, was there a counterclaim? I don't know about it.
Oh, she's moving to dismiss that case at this point. That case involved damages and violations of the lease other than rent. This case the second case involves purely unpaid rent. So she's asking to.
Which is the same as the other claims that were brought up in that case.
The other one was mainly for fraud. And I never got a counterclaim, so I.
Clearly, throughout the entire proceedings, she filed effectively what have been counterclaims and defenses to the actions and claims against you in the first matter.
What did where's
I am not dismissing the case. I made that clear the last time. I went through it with the parties. So to the extent, counsel, there is a motion to dismiss that case, it is denied.
We wish to proceed with the proofs as to the rent.
Here's the problem, and I explained this to Miss Anderson the last time. Why would I permit a judgment in this case when rent has been paid and was part of the other case I just now didn't dismiss? Why would I do that?
There's rent that's due that is not paid. So that's why the second case was filed. And there's unpaid water bills, and there were other costs involved.
3 months rent, water bill, court cost.
All of that was being handled in the other matter. So, as I was here the last time, I don't understand why I have this new case.
It was for the unpaid rent because she hasn't paid September, October.
Ordered escrow, what did you think was going to happen?
She hasn't paid it.
I said, are you claiming that in the last case there was no claim for rent?
The last case was for fraud.
Are you claiming that there was no claim for rent?
Yeah, there's a claim for rent and.
Exactly. That case is still pending, which means the rental claims, which will go month to month, are still pending. And now I get a new case,
I thought you were gonna.
which just doesn't make any sense to me. At the last hearing, I told you it did not make any sense to me as to why it was filed. None whatsoever. And if you think what I'm going to do is take a new case, rule on that while the other case is pending, not going to happen. The other thing is there's a problem violation of the court rules because she has to give, and I don't think she did. Well, maybe she did. For whatever reason, I don't even know why one would do this. Is that 7-6? The other one ending in 2176.
This is such a mess. I don't know why. What he's saying here, and I don't know why he just doesn't rule. Just say, your motion to dismiss the first case is denied. Next. That's what's going on. I agree with him, but I don't know why we're getting in our feels about it. The first case can't be dismissed. There's a counterclaim. Your motion to dismiss that is denied. I'm not discussing the second case until we resolve the first case. Proceed. That's all you have to say.
This one.
Yes.
All right.
And I believe that white file. The two.
So I don't understand why I have two cases.
Well, then let's proceed.
Because the plaintiff is stupid. You understand perfectly well, Judge Simpson. I agree with you on all of this. I just don't understand why you're not more direct. You've got the black robe on. Make an effing ruling and continue. I like him, but he gets like this sometimes.
As the court wishes to proceed, Your Honor, you entered an escrow order in this case, was it?
Yes.
And I wish to advise you that
In which case?
The first piece.
the first case, okay,
That's from.
I did.
it's not been paid for months of October.
What do we have as a escrow? Do we know?
3 months have been missed. It's not been paid.
Miss Lyman?
Yes, I haven't paid the 3 months, but I have the 2267 going on this week, and October, November will be in by the end of this month.
By when?
By the end of this month.
My client just checked with the court clerk today, and there's only $6,600. That's 2 months' rent.
I just said I will be paying the 2267 this week.
All right.
And
Because it's an escrow order, the only thing that happens is I set it for an immediate trial if there's non-compliance. We were at the point of getting a decision on the case. Are the parties going to be ready to try this in a couple weeks? Because I'm not trying it today.
Yes, we can be
Because
ready.
these pleadings are all out of order.
We can be ready to try it in a couple of weeks, yes.
Would you be ready?
yes.
And you say you're going to have escrow cleared up by the end of this month?
Yes.
Second and ninth.
Yes.
Non-jury trial will be set December 9th, 2025, 9 a.m. on both cases. Why I'm ruling on the other one, I don't know. All right, thank you.
The second case will be rendered moot by the ruling on the first case. This isn't rocket science. You resolve the first case, and then you say, what are you asking for in this second case? It's already been taken care of. You can dismiss that sua sponte if you want to.
Court does call the case of Lakestone Apartments versus Chartavia Misha.
Mr. Baker?
Yeah.
You have other clients here in the courtroom?
I do not. Mr. Phillips and Ms. Harriman are both lodged in the Otsego County Jail.
Mr. Baker, if you come forward to the podium there, please. On record is People versus Benjamin Baker. This is file number 5439 and 5488. I guess counsel put your appearances on.
Sierra Coke on behalf of the people.
James Dick on behalf of Mr. Baker, who's standing to my right, Your Honor.
Okay. And Mr. Dick, can you tell me the status of these files today?
Yes, Your Honor. We have a resolution to each of the files. The older file, Mr. Baker will be pleading guilty to domestic violence with prosecutor's consent to 769.48 in exchange for a dismissal of the other charges. And the newer file, Mr. Baker will be pleading guilty to 1 count of resisting and obstructing in exchange for a dismissal of the original charge.
So I guess we need to clarify some case file numbers.
Sorry, my apologies.
So 5488, that's aggravated stalking. That's what you reduced to misdemeanor domestic violence.
No, that will be the one that is going to,
We're adding a count of RNO to that case.
Oh,
yes. My apologies.
that's all right. And so then in the other file, 5439, you'll plead guilty to count 5, which is the misdemeanor domestic violence.
Yes, Your Honor.
Is that correct, Ms. Cole?
It is.
Mr. Baker, have you had an adequate opportunity to speak with Mr. Dick about this plea agreement? Yes. Is that how you wanted to proceed today? Sure. Okay. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Sure. Mr. Baker, are you currently on any kind of probation or parole? You understand that by pleading guilty to resisting or obstructing, that is with the maximum possible penalty of up to you for a $2,000 fine? Sure. Yes, that's an act of violence. As a first offense, is a misdemeanor that carries with it a maximum penalty of up to 93 days and or a $500 fine. You should. With those maximum penalties in mind, what is your plea to each of those charges today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights. You should understand that you're going to be giving up and waiving all of those rights by pleading guilty. Sure. Also, you don't have an automatic right to appeal the plea that you made here today. You only do that by leave. That means that you would have to ask for the Court of Appeals for your case. If they said no, then you wouldn't be able to go any further with that appeal. Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've discussed here in court? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to both of these charges because you are actually guilty of each of them?
Sure.
So, back on June 20th of 2025, you recall that day?
Yes, sir.
Okay. On that day, did you have an altercation with Alicia Bruce?
Yes, sir.
Is that a person that at the time that you had a dating relationship with?
Yes, sir.
Where did that incident take place?
In an apartment.
Where's that located?
31 Cobble Creek Drive, Grayling.
Exciting and new.
Crawford County?
Yes, Your Honor.
Okay, and what happened that would make you guilty of assault? Yes.
There was smoke. We had an argument. There was smoking in the bathroom. I tried to get in. I pushed the door harder than I should have and struck her in the face.
All right. And then another incident on October 1st of 2025. You recall that day?
Yes, Your Honor.
And on that day, did you come into contact with some law enforcement officers?
Yes, Your Honor.
Did you know that they were there doing their job or engaging in their duties as law enforcement officers?
Sure.
And what would you have done in that incident that would make you guilty of resisting or obstructing one of those officers?
I failed to open the door for them.
Okay. And they were asking you to do that as part of their investigation.
Yes, Your Honor.
Ms. Koch, would you agree that we have a factual, did that occur within Crawford County as well?
Yes, Your Honor.
Ms. Koch, are you satisfied with the factual basis as to each charge?
Yes.
Let's do that.
Yes, Your Honor.
So are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
No, Your Honor.
And counsel, are you both satisfied that the court has complied with statute court rule in favor of this?
Yes, Your Honor.
Yes, Your Honor.
Mr. Baker, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will be in touch with you for a pre-sentence report. Ms. Koch, is there anything else we need to address for the record today on your side?
No.
I know, Your Honor.
All right, thank you. That's all for today.
Thank you, Your Honor.
Yes.
Yeah.
I
What's that
not
mean?
without being at my desk.
Oh, no. Yeah.
I've got all the stuff written on there.
I think that was a list of extras, or maybe for parents.
But she,
Parents, that's the big.
she apparently called James Dick and left a message saying that there was a big misunderstanding and this case should be dismissed.
She don't, yeah.
Well, they were communicating. He came in and they looked at each other, googly eyed. So
Yeah,
Oh, is it
she was
from-
telling us things to violate it.
Is this the girlfriend?
Yeah.
So Mr. Johnson, Brandon Johnson called me on her behalf because she wants to send a letter to the judge saying this is, you know, they want to get back together. They want to be together. I said, well, you need to give me a letter. I'm like, I don't know.
That she was now dating Brandon Johnson.
I think Brandon Johnson would be a good advocate for her.
Yeah, it's,
So I talked to him.
yeah, they're dating.
Wait, what?
Brandon Johnson is now dating the victim on
Baker.
Baker, who wants to get back together with Baker.
It's a love triangle.
It's gonna end well when
Classic
Baker
love
gets,
triangle.
when he gets out of jail.
Southside, love triangle.
Well, Brandon should be here tomorrow for court.
Good.
That's the Cobble Creek, Lawndale, love triangle.
So, I mean, that was my conversation with him last week is whatever. And he was supposed to be bringing me a letter, which I've yet to see. Or he's bringing me a letter she's supposedly writing. I don't know. I don't even know.
No,
anymore.
Brandon, no, Brandon's. I'm straight Brandon out here. Brandon's got his own troubles. He doesn't need to get involved in anybody else's.
See, I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Okay, so let's go on the record in the matter of Kings Forest Apartments versus Kenesha Tagger, Alonzia Tagger, 2501967.
Good morning, Your Honor. Nick Balberman, on behalf of the plaintiff.
Okay, your P number, counsel?
35262.
Okay, counsel, do you have a tie on?
No, I forgot. I'll go get, you want to pass the matter and I'll go put one on? I forgot.
Counsel, I'm just slightly confused. You're in court. I'm not sure how, as an attorney, you forget to have a tie on.
I understand. I'll have to go do it.
Do you have your suit jacket as well, or what?
I think so. Yes.
Yes, counsel, that's an expectation of the court. Absolutely.
I'll go see if I have a coat and tie. I'm sorry, Your Honor.
We're on the record in the matter of Mike Vigilante versus Rachel Duncan, 2501. And we are on the record in the matter, we're recalling the matter of Kings Forest Apartment versus Kenesha Tagger, Alonzia Tagger, 2501967.
Nick Balberman for the plaintiff, Your Honor, P35262.
All right, thank you. And are the tenants present?
Yes.
Yes.
Good morning, Your Honor.
Good morning. Your name for the record, please.
Kenesha Tagger, Alonzia Tagger.
Okay, very good. Thank you. And so today is the date scheduled in this matter. And counsel, do you have an opportunity to speak to the tenants in the breakout room?
Yes.
Okay, and has there been a resolution or what's the status?
Yeah, there's been a resolution. The resolution is that the tenants will pay $900 today, $600 on Thursday of this week, and the balance by the last day of this month. And that balance would be $1,160.08.
$1,160.08 would be the balance.
Yes.
Okay. And then counsel, if one of those payments is missing, what is your requested writ date?
The writ date would be December 1st.
Okay. And Kenesha Tagger, did you hear the terms of that judgment?
I did. Yes.
Alonzia, did you hear the terms of that judgment?
Yes.
Okay. And you both understand that Mr. Balderman represents the interests of your landlord and not your interests, correct?
Yes.
Alonzia?
Yes.
Okay, I need to see Alonzia. I can't really see.
Yes.
Are you wearing a tank shirt?
I'm wearing the sundress.
Ma'am, okay, your shoulders need to be covered, please. You're in court.
Okay.
So please go grab a sweater or something. You also understand your rights that you received in your packet of information. Is that correct?
She's asking you. Yes.
Kenesha, also you.
Yes.
And do you have any questions regarding those rights?
No.
All right. And Alonzia, do you have any questions regarding those rights?
No.
All right. You also understand your rights under the court rule, correct? Mr. Balberman, did you explain those rights to the tenants?
No.
Counsel, that is, okay. Explain those rights to the tenants, please.
You have a right to appeal this hearing if you'd like, and if you don't pay the rent by the due dates, the writ would issue.
That's not quite the court rule, counsel. Kenesha and Alonzia, if in the event, because you're not represented by counsel, if in the event you have good cause or you were mistaken about something, then you have 3 days whereby which you can request the court set aside the judgment.
Okay, thank you.
All right. And so knowing all of that, Kenesha and Alonzia, do you have any questions?
No.
All right, the court does find the waiver of rights as valid. The terms of the judgment are reasonable. The court does will order by consent. Plaintiff does have the right to recover possession of the property. The amount not due and owing for unpaid rent and other costs. Well, counsel, what's the total amount due?
Total amount due is $2,660.08.
All right, the total amount due is why did that not type? $2,660, correct?
And 8 cents.
And 8 cents. Okay. Something didn't go. All right. That amount is to be paid as follows: $900 by November 17th, which is today. $600 by November 20th. The balance of $1,160.08 by November 30th. If any of those amounts are not paid, plaintiff apply for an order evicting the defendant. I'm sorry, if those are not paid by December 1st. If any of those payments are not paid, then on December 1st, plaintiff may apply for an order evicting the defendant. Additional money may be owed of bail if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter. Do you have any questions?
No questions.
Okay, good luck to you all. The court will sign it upon receipt.
Can we sign their name? Can we sign their name to the judgment, Your Honor?
You have to ask them, counsel.
Ms. Taggers, Kenesha, and Alonzo, is it okay if we sign your name to paperwork with that regard?
Yes. Yeah.
Okay, thank you.
All right. Okay. The court will sign it upon receipt. Thank you.
Thank you.
Have a good day. And thank you. We're on the record in the matter of Kings Forest Apartment.
My apologies about my delay, folks. Court does call the case of Gil Sanford versus Susie Norman.
I don't know what's going on here.
Your name, sir?
Gil Stanford.
Either place is fine.
By the way, all this is Law Nerds Unite's fault, aka Zach. And well, that's not quite true. Lots of the usual suspects were involved.
And your name, ma'am?
Susie Norman.
Okay. I had you two here before a long time ago.
Yeah.
7 times.
Thank you for counting. Okay.
Good morning, Judge.
Good morning. And then there was a general civil case which was filed, and that now has been assigned to me. Judge Barr had it for the purposes of judicial efficiency. So that's where we are. Where are we with these cases? Anybody can go ahead. Go ahead, sir.
I have filed a request for 12th entry, and she has asked to open up a previous case that I filed an objection to.
You objected to the opening of the 2024 case, right?
Pardon me?
You objected to the opening
of her
of the 2024 case.
Yeah.
Okay. All right. So I'm just trying to get my files right here. I think your claim, sir, which is in the case. Well, maybe I gotta.
You know, give you a quick overview.
No, I'm just making sure I have the right files. I may need it in a second, but when I looked at this before, because now I have an extra file, which was the one she wanted reopened. Okay. Ms. Norman, what's going on from your position in this?
Well, it was my understanding that in October of 2024, the case was finished. Like I said, you know, there were 7 cases, or excuse me, 7 times we came in front of you. I had a case against him. I dismissed it for the possession. It was a possession case. I had a case that showed that he had no certificate of occupancy. The house was not habitable, you know, per the township rules. And just to get some peace and to keep, you know, out of court one more time, we dismissed my case and I thought it was over. I had money in escrow. We split that. So I thought it was over. And now here we are again. And I did send a motion to reopen my case, you know, if this is going to go further, so that everything kind of gets heard and finalized.
Let me ask this, sir. Well, right now I have a October 22nd, 2024, but I think that case was dismissed. There was a conditional order of dismissal that was to follow in the 2024 case. So what is your claim, sir?
My claim is for physical damages that her and her family caused to the property and lost rent.
Well, what happened to, in the month she left, what happened to the security deposit?
Are you asking me?
Yeah.
She did not have enough money paid into to fund a security deposit. She did not have that initially when she first moved in. And she was trying to get caught up on that, but she never had enough money to fully fund a security deposit. I sent her a letter after she moved out listing images that basically you know, she did not object to that. That was the damages, was about $7,000.
Oh my God, say something, spit it out. I'm going to lose my freaking mind.
Physical damages to the house. But there was not a security deposit being held.
Okay, well, here's the other issue. Was there, as I'm recalling in the case, and it's all kind of coming back based upon some of the things you're saying, the house did not have a COO.
At the time, or during the course of her tenancy, I was not aware that it had expired, and you're correct. There was not that COO. After she moved out, I made the corrections, and I have a new COO. And I think.
But during the time that she was renting, you didn't have one.
That's correct.
So you're first of all claiming, I understand that you have damages and you said rent, but
And the rent,
how much are you claiming in rent?
the rent, and the rent that I'm claiming is all after the cedar.
How much are you claiming in rent after the yeah, but go ahead.
I don't need that. Let's see. Well,
Since you're seeking rent, how much you're claiming in rent would be something that you would kind of know. Like that would be one of the top line figures you'd have handy before you got to court.
my total, on my initial, complaint and amended complaint was 29,179. And prior to that, it was, the damages were, 7,000 something. So whatever the difference is there. I have to do some math to get an exact number on that.
Okay. You told me at the beginning you're claiming damages and rent.
Correct.
So of what you're claiming, how much rent are you claiming?
That total,
let's try the other way. How much damages are you claiming?
the damages were, I thought I had that separated on here.
Do you appreciate that somebody shows up to court and has no idea what they're effing asking for? This is literally like just saying, Judge, I'm here with my hand out complaining, but I don't know what I want.
The damages or what I'm claiming for damages was $7,138.17.
7,000 what?
$7,138.17.
And those are all damages that you say are relating to her occupancy of the premises.
That's correct.
Okay. And what? And the rest is rent?
And so, so it is, $22,041.36 is the total complaint. So if we subtract 7,000 from that, is whatever that comes to.
So, sir, how are you? Let me just ask you this. If, and this is in regard to the rent claims, if at the time she occupied the premises, you don't have a COO, and as such can't charge rent, theoretically, how do you then at some point begin charging her rent after she's left?
Because we had a lease that went through,
But the lease is going to be void, sir, because you don't have a COO. You can't enter into a lease legally.
Well, that was a contract that we agreed to, and
Okay, you can agree to whatever you want to, but you're asking this court to basically enforce what may be an illegal lease.
I made it legal when I got the COO.
But she had already left.
She vacated at that point in time after we had our other case.
I made it legal, Judge. I actually get this a lot from insurance companies who try to do stuff contrary to the law. Well, no, we put it in our lease. Yeah, I don't care. We put it in our contract. I don't care. It's contrary to Illinois law. You're still subject to it. You can't contract around it. I've had decades of this stupid argument.
Okay. But
And I corrected the oversight that I did not have COO.
but she's no longer there.
No, she's not.
So maybe follow this. If you're not permitted legally to enter into a lease, but you sign a lease, the question for the court is whether or not that lease is void, because you can't legally do that. But what you're then attempting to do is take part of that after you've had an agreement regarding her leaving the premises. She leaves the premises. You then make your corrections, get your CEO, and now want to charge rent on a lease that was probably void from the beginning.
I guess the question is,
No, I like my question better. And that is, how do you do that?
well, was the, I'd have to look at the law. Does the law say I can't charge, or without the COO, I can't?
I like that. That is fantastic. I'd have to look at the law. Yeah, that's something you want to do before you toddle into a court and talk to a judge about a specific topic. The time for looking at the law was before the hearing. It's just not something you're thinking about now.
Charge rent, or I.
Spoiler alert, you're wrong.
You can't rent.
Pardon me?
Theoretically, you can't rent. You can't rent the premises.
I understand what you're saying, yeah.
Which means, since you can't rent it, then my question to you would be, if that's the case, how can you sign a contract to rent the premises?
Well, we did that. She moved in and she damaged the property, so.
I'm just talking about the rental portion right now.
I understand what you're saying.
But then it gets even, because in the 2024 case, which I understand why she wants to reopen, the claims were basically dismissed, rent waived. There was then a split of the escrow between the two of you. So at that point, the relationship from a tenancy standpoint ended.
What was agreed to in the dismissal of that, there's a statement in that line number 6 that says the defendant may be liable for money damage for additional rent or damages to the property.
Okay. I'm not dealing with the damages right now.
Right.
I'm dealing just with the rent. If you couldn't charge rent from the beginning, how can you then decide to charge rent?
I see what you're saying. I understand your legal argument there, and
I don't make legal arguments.
I see what you're saying there, Judge. That's a really good point. Oh my God. This hearing goes on a while. I don't know how. I'm curious now.
well,
I make rulings
all right.
that everybody says.
So I
Good or
see what
bad.
you're saying. So maybe that's the case. I cannot charge the rent that I'm asking for this.
Okay, that got you there. So now your claim is 22,000?
No, the damages are 7,138.17.
So now that's what the fight is about.
That's correct.
Okay. So when she moved in, let's just try to get some things clarified. When she moved in, was there a rental check-in list?
There was.
Was there?
Yes.
Do you have a copy of it?
I don't know that I do have that with me today. That's in my other file from the previous case. But there is a check-in inventory list on that.
Pardon?
There is that inventory condition.
Okay. So you have the one that she filled out?
I don't believe she ever filled one out.
So where is this one coming from?
Where is, I have one that I filled out when she moved in. I have another one filled out when she moved out. I do not have that with me today.
You have one that, say that again?
Pardon me?
Say that again to me?
I have one that I filled out when she moved in. I have another one I filled out when she moved out. I gave her a copy of that original blank form. She never filled that out and sent that to me.
So there isn't an inventory checklist.
There is a
So there really isn't.
Yes, I have my copies of that document.
Okay. Prior to renting to her, did you rent to somebody else?
It had been rented previously, yeah.
Do you have their inventory checkout from the previous tenant?
I do have that also.
Okay. Did you send her a list of the damages you're claiming?
I did.
All right, Miss Norman, what's your response to the damages?
Well, first of all, I did fill out the inventory checklist, myself and my daughters, and I did submit that to him. What was the second? I'm still back on. I did.
Oh, it's okay. Did you get a list of the damages that he's claiming?
No, I did not. What I received was the filing from 6/3 for the damages. He never returned any of my security deposit, so he's incorrect. And in that file, and I hate to go back, but in that file, there are money orders, several of the payments that I made to him. So I did not receive an itemized list within 30 days. The first time I'm hearing.
Did he have your forwarding address?
Yes, he did. And so did Mr. McCurgy, who was an attorney for him at the time. So they both had it. And I did receive the 6/3 filing paperwork at that forwarding address. I did not receive anything else, but apparently he filed something in December that was just.
Okay, so, ma'am, how much are you claiming you paid in the security deposit?
$3,500.
Sir,
Yes,
do you agree that she paid $3,500 in a security deposit?
I do not agree that.
How much do you think she paid in a security deposit?
I'd have to review my records, but I think it was.
Hold on. When you sent out the sheet to her, you had to subtract out, you would claim damages, and then you had to subtract out what you had.
And I had no money in security deposit because,
Well, hold on a moment. You just told me a little while ago that you did because she didn't pay it all.
when she moved in, she did not have enough money, all of the cash that I required for her to move in. She was short the money that would be for the security deposit. She said she was going to pay that and get caught up on that. Hindsight is always 20/20, but she never got caught up on that. So she was all.
So she's saying she paid $3,500. You're saying she didn't pay any.
She did not pay $3,500.
Different answer. She's saying she paid $3,500. You're saying for a security deposit. You're saying she paid nothing for a security deposit.
My recollection is that she did not. Again, I'd have to look at my notes, my numbers.
Sweet Jesus. What?
Told me two different things here today, at least. As we sit here right now, can you tell me whether she paid a security deposit?
She, I don't believe she paid a security deposit. I don't believe she paid enough money at move-in to cover.
How do we not know that?
What's that?
How do we not know that? We being figuratively, how do you not know that?
Well, because this whole episode of her tenancy was a constant battle trying to help her get caught up. I had offered her a couple different options for payment plan on that, and she kept shifting gears and paying me oddball most of the money. It was the accounting was rather convoluted.
In your lease that may be void, does it say she paid a security
deposit? The lease calls for.
I haven't seen this, but it better end with "you'll get nothing." You'll get nothing and like it. There is no other place to go here.
I believe it was $3,500.
Let me ask that. Does the lease say she paid a security deposit? The lease should indicate that she paid a certain amount for a security deposit. It should also then indicate that you are then holding that basically in trust, and it should then list out the financial institution at which you are holding that security deposit.
That's what the lease states, that the security deposit amount was, and again, I think it's at $3,500. I don't have that lease with me. That's in my file for the other case. Wasn't ready to tackle this part of it.
I don't know what that means. So you would agree, at least as we sit here right now, that the $3,500, the lease indicates she paid it and that you're holding it at a particular location.
No, I would say the lease calls for that dollar amount, but she never paid it. I gave her a receipt for the money that she did pay, but she did not pay all the money that was due at time of movement. And I can, we'll have another preliminary examination. I can bring all that documentation in, including the,
I would give anything to be in a preliminary examination right now, but no. All right. So Norman, anything else you want to say?
All of the receipts that I paid are in the file. That in the case that I'm asking the court to reopen, I was paying Mr. Stanford $2,126 every 2 weeks. He is in
How much was your monthly rent?
$3,300. And to get caught up on the what he was saying, I'm behind. I was paying him $2,126 every 2 weeks, and those money orders are in that file. The court has.
So you're saying by doing that and paying this excess amount, you paid the security deposit?
That is correct. And I up on move-in. Actually, I was on a travel assignment. I'm a travel nurse. I was on a travel assignment and I sent him $4,000 to hold it. So that was over the $3,300 first month's rent. And then when I got there, I paid him $1,750. So all of that information, the court has.
So you gave him $5,700 at move-in?
I believe it was $5,750.
Okay. Sorry. Didn't mean to leave out the 50.
Oh, no.
So, no, it's okay. So you paid, you recall that, sir?
she did make a large payment.
Okay. Not what I'm asking. Do you recall her giving you $5,700?
The exact dollar amount, I'd have to check the records. But yes,
Okay.
she paid,
A sizable amount.
a sizable amount, yes.
So if she paid the 57 and rent was 3,500, 3,300 a month, what did that difference represent?
I'm sure it's still dry here. My lease calls for certain things that if she pays money, that money is allocated to.
Okay, here's what I'm going to want. No, we're gonna stop today because everybody else in here probably wants dinner, and we're never gonna get there. All right, so I'm going to adjourn this out. Ms. Norman, I want to make sure do you have a list of damages he's claiming now?
I do not.
All right. You are to supply to Ms. Norman a list of the damages you're claiming. Understood?
Understood.
I also then want an accounting from the landlord of all monies paid by Ms. Norman.
Okay.
I then want, and again, this has to come from the landlord, I want the previous tenant's inventory checklist.
Yeah, and Miss Norman better do an accounting of her own. If she hasn't already, I think she's provided this. I can't tell. I can't tell because I lose my mind listening to this guy say, But this guy will just make stuff up.
As well as the previous tenant's inventory checkout list and the initial and concluding inventory checkouts for Miss Norman.
Okay.
Understood?
Yes. I believe, and I can't. Yeah. I did an extensive amount of work to that property just before she moved in. And I can document I give you, show the work orders of all the things that we did on that property before she moved in. But I can.
No one cares.
I give you those things and I'm going to include that.
Why are you telling me that?
Well, because the
previous tenant's inventory checkout list doesn't look good.
well, the house had been rented through Washtenaw County as a halfway house for Michigan Department of Corrections people to be basically coming out of prison. That had been rented that way for several years. There was some rough conditions of it, and we went through and replaced a whole bunch of things. Made sure,
But that would be, I guess I hear what you're saying, but that would be that should be clarified on the move-in checklist.
Yes, it is.
Okay.
From this Norman, right?
Yes.
And it is very clearly stated in that.
But you're saying she didn't fill it out. You're saying you filled it out. But she's saying she did fill one out.
Maybe she did. I have to check on her.
So you don't know?
Not off the top of my head. I don't think she did.
All right. You just told me that she. Okay. All right. Fine. I just want both of them, the previous tenant and hers.
That's
all right. So everybody got what they need to bring me, and I need it sent to the court. How long is it going to take you to pull all that together, sir? Because that's really
3-4 weeks.
Wow. Okay.
Whatever.
No, that's fine.
I will put together photographs and whatnot of all the things, including condition, so you can see all the information. I'll send a copy.
Well, I get that, and you can include them if you want. But right now, I got to figure out what the heck we're fighting about, or you guys are fighting about. We're not fighting anything. Oh, and what's the one after that? Got it. Okay, so if it takes you 3 or 4 weeks to get that done, and then that's going to put me mid-December, Ms. Norman would have to look at it and respond as she deems it appropriate. So what I will do then is I'm adjourning these matters to January 6, 2026, 9 a.m.
And cancel the non-jury trial on December 16th.
Oh, yeah, that's canceled. Yeah, that's
January 6th.
That is so canceled.
And at what time?
That'd be at 9 a.m. Because we got to figure out what we're fighting about.
Yeah.
Okay. What date are you going to get these to the court?
Month from now.
All right. And today's the 18th, right? All right. You get those to the court by December 19th.
Right.
All right. Anything further from either side?
Judge Simpson, will you rule on the motion to reopen my case? Part of the reason why this journey started was because the house was inhabitable and I called the township for an inspection. So all of
Go ahead.
I see your hand go up, so I stopped.
Yeah, I know. That usually means be quiet, but I realize you're on Zoom. But go ahead. I'm listening.
Okay. So that is all of that information and damages and mold and all of the things. I have photographs in that file.
I know. As you guys were talking, it's kind of like having a bad dream. It all was coming back to me.
Yeah.
So I remember the whole thing, kind of.
Yeah, I figured that you.
And so I know that exists. I don't know for the purposes for which you want to use it for, that I need to necessarily reopen the case. Because I realize there is evidence in that case that you may want to use, and I don't have a problem with that. I don't really want to reopen it because there was an agreement between the parties that goodness knows I don't want unraveled, because that becomes my start.
Yeah. And I get that.
So at this point, I am going to deny your request to reopen without prejudice, meaning at some point, either the court or you can raise that again, and I may reopen it if that becomes an issue. Okay?
Yeah. Just one other question.
Sure.
So as far as the deposit goes and within the 30 days and me not receiving that, wasn't he past his time limit?
Okay, I can't answer that because I'm not clear on any time limit, because you have to understand that I can't begin to even go through that analysis when you're telling me you paid a security deposit and he's telling me you didn't pay any.
Okay.
So I have to first figure out whether or not there's a security deposit, and then what that is subject to, and then whether or not the other parts of the statute have been followed.
Okay.
Make sense?
It does.
I know. Everything I say makes sense. Thank you for saying so. All right.
Welcome.
All right. Okay, folks.
See you in January.
We'll see you in January. Have a great Thanksgiving. Happy holidays. Take care.
Thank you. Take care.
Yeah, all righty.
Is CR 2025-00683.
Okay, this is Rosalind Duke's fault. It came through during this stream. So it's new to me. I don't know how old it is, but it's new to me. I have not seen it. Let's see what Old Tonsil Twins is up to. It's not very long.
1 State versus Laura Owens. Time set for a complex case management conference. Kind of appearances, please.
Jennifer Lett on behalf of Ed Leiter for the state, Your Honor.
Thank you.
Good morning, Your Honor. Sandra Schutz with Cold Root Law Offices on behalf of Laura Michelle Owens. She's out of custody and present, standing to my left.
All right. Ma'am, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
Okay, thanks. I did get the complex case management report. Then I also got Ms. Schutz's motion to withdraw. Ms. Owens, I know you wanted to appear here virtually, but now that the council issue came up, need you here in person to figure out what we're going to do moving forward. So what I'm going to do is I will grant that motion to withdraw.
Ooh. So her attorney in the criminal case is withdrawing, and now the judge is saying you need to be here personally for all appearances. That's a lot already. What are we, 30 seconds into this thing?
Ms. Owens, was your intention to hire another attorney, or how did you want to proceed?
Your Honor, I'm going to need to have a public defender.
Okay, so I did review a previously submitted financial affidavit and reviewed my previous determination regarding imminency, regarding appointments of experts. I'm just going to affirm that finding. I'm going to appoint the Office of Public Defense Services to represent Ms. Owens.
Miss Owens is a brokey. She's a big brokey. I just want to say it because I wouldn't do this to most people, but she's a nasty person and she thinks she's better than other people. And now she's in here, hat in hand, begging for the taxpayers to pay for her attorney because she tried to scam an innocent man into being the father of her twins. So suck it, Laura Owens. Well, I guess she already did. Now that I think about it. All right, let's carry on, shall we?
Ms. Schutz, you're going to be relieved of any further obligations in this matter. What I'll do we have a availability next week for a status conference?
Where's the article for me?
Oh, that is Thanksgiving. How about the following week?
December 2nd at 9:10.
Right. So, Ms. Owens, there's a little bit of administrative delay between my appointment and when they actually assign a lawyer. I'm going to set a status conference for December 2nd at 9:10. By that time, that administrative proceeding should have occurred. You'll have your new lawyer. They should be here to meet with you on that date, and we can discuss our future dates moving forward. There is a chance, though, since whatever lawyer gets appointed may not be available that day, that I might have to move that date slightly. So if you could give us your contact information, give that to my courtroom assistant. What we'll do is we will forward that to the attorney that is appointed to represent you, and also that way they can get in communication with you if you have to move that date. Got it? Okay, but December 2nd at 9 o'clock is the date you need to be here in person.
Okay.
If you don't show up, a warrant could issue for your arrest. All right, I think that's pretty much all we can do today, given the status of her attorney. Thank you. We are in recess in this matter.
Thank you.
Thank you.
You lit a match in the tabloids, watch the fire spread fast. Too little lies in a cradle of glass. You painted halos on shadows, wrote lullabies for ghosts, but the elaborate scheme was conceived in your throat. You played your part like a movie queen, a silver screen lie in a magazine dream. You said they were real, but their points spin. Whispers made flesh, your tonsil twins. Your baby bump hit a pillow with it. Play it, pretend till the truth walked in. The spotlight fades and the lights grow dim. Now who's gonna hold your tonsil twins? Your script was a mouthful, too hard to conceal. You spat out your lines, but choked on the reveal. The truth was a burden you couldn't swallow low down, and the stain of your tail splashed on your gown. It's hard to keep your story straight when the paper trail shows no due date. You said they were real, but they're born in your spin. Echoes and rumors, your tonsil twins. You dance on the edge just to reel them in. Your whole defense started to spin. Now all that remains is a stain on your chin. Nobody's buying your tonsil twins. Detectives knocked on the door one more, woke you up where the lie was born. Your load of lies, now a sticky mess. Every word you spoke is a stain to address. You said they were real, but they're born in your spin. The verdict comes down, you'll never win. Thirsty for fame and TV shows, you got left drinking from an empty hose. Now the truth's been shown and you're all alone, left all alone with your tonsil twins. Your tonsil twins. You're all